Welcome to the Trade Advisory Network YouTube channel. I'm John Bougere, co-founder and managing director of Trade Advisory Network. On this channel we publish short educational videos on a variety of subjects concerning trade and supply chain finance. This first series of videos focuses on URDTT, that's the Uniform Rules for Digital Trade Transactions, which was published by the ICC in October 2021, and this is episode 4. This series is made in association with ITFA, that's the International Trade and Forfeiting Association, and also with LIBF, the London Institute of Banking and Finance. For those of you that don't know us, Trade Advisory Network was founded in 2014 by myself and my colleague Lionel Taylor. We deliver specialist trade and supply chain finance consultancy and education to commercial banks, development banks, fintechs, technology service providers, educational bodies, investors, and corporates. We also undertake expert witness assignments when trade finance related disputes end up in tribunal or court. If you feel that your organisation would benefit from direct engagement with Trade Advisory Network to refine and implement your digitisation strategy, or develop your trade and supply chain proposition, or to develop a bespoke education programme, please drop me an email or check out our website. Contact details are on screen and in the video description. In this episode, we will be looking at the use of electronic records. Now, the term electronic record is used in MLETR and was chosen for URDTT in order to provide some consistency. An electronic record is defined in URDTT as meaning data created, generated, sent, communicated, received, or stored by electronic means. In essence, an electronic record is a digital file. In the same way that a paper document contains information, an electronic record contains data. That doesn't mean that an electronic record is necessarily the digital equivalent of a paper document. But insofar as it contains information, it serves a similar purpose, which is to store information and to communicate it between parties. I've mentioned this before in previous episodes, but just to recap, a paper document has certain characteristics which are not replicated in a conventional electronic record. With a paper record, you can distinguish between an original and a copy. You can also have physical possession of an original paper document and can transfer possession to another party by physically delivering it to that party. Associated with the concept of possession is the concept of title rights. The holder of certain types of document has title rights by virtue of having possession of that document. Examples include negotiable payment instruments such as bills of exchange, where the holder has the right to get paid. Similarly, the holder of a negotiable bill of lading has the right to take possession of the relative goods. In both cases, the holder can transfer title rights by delivery. And unless the instrument is made out in favour of bearer, the delivery has to be accompanied by endorsement. The problem with conventional digital files is that they can be replicated any number of times. So the concept of an original doesn't really exist, which means you can't possess an original or transfer possession by delivery. Thankfully, the technology now exists to create and manage digital original documents that have the same characteristics as a paper document in terms of originality, possession, and transfer. So it is now possible for an electronic record to be used as a document of title. I covered this in more detail in an earlier episode and also discussed the legislative changes which are taking place as more and more countries become MLETR compliant. Moving on, the URDTT definition includes a couple of important qualifications. An electronic record must be capable of being authenticated as to the apparent identity of the submitter and the apparent source of the data contained in it, and as to whether it has remained complete and unaltered. This is an important benefit of agreeing that a contract should be subject to URDTT. This qualification provides much better protection against fraud than could ever be possible with paper documents. A second qualification states that an electronic record must be capable of being examined for compliance with the terms and conditions of a digital trade transaction. This is similar in principle to a paper document being checked for discrepancies relative to a letter of credit. Of course, with an electronic record, that check may be undertaken by a human being or may be undertaken by a machine. Article 7 provides 6 additional rules governing the use of electronic records. 7A makes the point that a DTT must specify the terms and conditions by which compliance of an electronic record will be determined. For example, if a DTT specifies that goods must have a pre-shipment inspection, then an electronic record would have to be submitted that provides evidence of that inspection. The DTT should also specify the party that must submit the electronic record and include any provisions regarding authentication and so on. Finally, the DTT should specify how the electronic record will be checked for compliance. For example, it might specify that the electronic record must be examined by the addressee, who then decides whether or not it is compliant. On the other hand, it might specify that compliance verification will be handled digitally by a data matching application or perhaps by a blockchain related process. 7B states that all data relating to a DTT must be submitted in the form of an electronic record. As noted earlier, URDTT operates in the wholly digital environment and does not accommodate a mixed paper-digital process. 7C states that any requirement for submission of multiple copies of an electronic record is satisfied by the submission of one electronic record. This recognises the fact that an electronic record can be infinitely replicated. This rule is, however, qualified in Article 7F, which refers to the concept of possession, which is linked to the concept of originality as mentioned above. 7D states that an electronic record that is submitted but not required by the DTT will be disregarded and disposed of by the addressee. This is consistent with other ICCE rules operating in the paper document space. 7E states that a requirement that information should be in writing is satisfied when an electronic record containing such information is accessible to an addressee and is not affected by data corruption. This rule is, however, qualified by the words "unless applicable law requires otherwise." In certain jurisdictions, the law might specify that an electronic record is not acceptable and that a paper document is a legal requirement. As more and more countries adopt the principles of MLETR, however, the situations where an electronic record cannot be used will become increasingly rare. Finally, 7F refers to the use of electronic records as digital original documents. URDTT is technology agnostic, so this rule does not specify the technology that must be used, but talks in terms of exclusive control of the addressee. This is the equivalent of possession under MLETR. As mentioned earlier, electronic records must comply with the terms of the DTT. If they do, and all of the DTT's terms and conditions have been fulfilled, then the conditional payment obligation of the buyer becomes unconditional. So what if an electronic record does not comply with the terms of the DTT? It is discrepant. Article 8 of URDTT sets out clear rules governing the procedures to be followed. 8A states that the addressee must inform the submitter of the reason or reasons for non-compliance, and they must inform the submitter by 23:59:59 UTC on the second business day following the date of receipt. Just to be clear, in other words, that means not later than 1 second before the start of the third day. There was a lot of debate amongst the national committees regarding the time allowed for non-compliance. Many wanted longer. Arguably, however, 2 days is still longer than is necessary, given that compliance verification will normally happen digitally and it'll happen within seconds of receipt onto the platform which is hosting the DTT. We settled on 2 days. 8B talks about the various remedies for non-compliance submission. When I say remedies, these are the options for completing the DTT notwithstanding the discrepant submission. Whichever of these 3 options occurs first will result in the DTT being completed. So option 1 In this option, the submitter replaces the non-compliant electronic record with a compliant electronic record. However, the replacement electronic record must be submitted no later than 23:59:59 UTC on the latest date for submission specified in the DTT. In other words, the deadline for submission is not extended as a result of a non-compliant record being replaced with a compliant record. Option 2. The principal parties, they are the seller and the buyer, may amend the terms of the DTT, resulting in the electronic record becoming compliant. However, if there are any obligors other than the buyer or beneficiaries other than the seller, and these are parties to the DTT, they must also agree to the amendment, as their rights or obligations would be affected by the amendment to the DTT. So if any obligor or beneficiary declines to agree, the amendment cannot take place and the electronic record will remain discrepant. So you may be wondering how there can be additional obligors or beneficiaries during the period when the electronic records are being submitted, which is before the DTT has been fulfilled, and the obligations are therefore still conditional. As explained in an earlier episode, an FSP payment undertaking can be added to a payment obligation any time, including when it is still conditional. So the FSP that adds its payment undertaking is an obligor as soon as they add their FSP payment undertaking, albeit it's still conditional at this point. So you can have additional obligors. Similarly, a payment obligation can be transferred to another party, making them a beneficiary under the DTT at any time when the payment obligation is still conditional. So you can have additional beneficiaries. Option 3, actually similar to option 2 with regard to the parties that must be in agreement, but instead of amending the DTT, they agree to accept the discrepant electronic record, notwithstanding its non-compliance. Once again, the principal parties and any other obligor or beneficiary must all agree, otherwise the discrepant electronic record cannot be accepted. Article 8C specifies what happens if the addressee fails to inform the submitter that an electronic record is non-compliant within the timescale specified in 8A. Basically, the addressee will lose the right to reject the electronic record due to its non-compliance, and the electronic record will be considered as having been accepted by the addressee. Let's talk about data corruption. Article 9 sets out the treatment of an electronic record that appears to have been affected by data corruption. It may be obvious, but it's important to distinguish between non-compliance, Article 8, and data corruption, Article 9, although some of the steps are actually similar. Article 9 states that, Article 9A, I should say, states that the addressee must inform the submitter that an electronic record appears to have been affected by data corruption. The addressee may, at this point, request that the electronic record be resubmitted. Article 9B specifies the time limit for notifying the submitter. Once again, the deadline for such notification is 23:59:59 UTC on the second business day following the date of receipt. If the addressee fails to notify the submitter within the specified timescale, the corrupted electronic record will be considered as being compliant with the DTT. Article 9C states that if a submitter fails to submit a replacement electronic record by 23:59:59 UTC on the latest date for submission specified in the DTT, the addressee may treat the electronic record as not submitted and may dispose of it as it sees fit without any responsibility. So just to clarify the timings here, the addressee must inform the submitter that an electronic record has been affected by data corruption no later than 23:59:59 on the second business day following receipt. The submitter must resubmit the electronic record by 23:59:59 on the latest date for submission of an electronic record specified in the DTT. Electronic signatures. Electronic signatures are a big subject in their own right, beyond the scope of this video series. The key point to note is that an electronic signature is binding in the same way that a wet signature is binding in the paper world. However, the presence of an electronic signature does not necessarily mean that an electronic record fulfills the requirements for a digital original document. The technology to create and manage digital original documents is entirely separate from the technology that adds electronic signatures. In most cases, however, an electronic signature will indeed be required on a digital original document, so both technologies will work together. The other point to make, as noted in Article 10, is that the conditions pertaining to the addition of an electronic signature must be specified in the DTT. For example, if the intention is to use, let's say, Signicat as the service provider for adding an electronic signature, this must be specified in the DTT. As a DTT exists wholly in the digital space, it follows that it must be recorded on a platform of some sort. This could be one of the consortia or any of the third-party platforms that have proliferated in recent years. But it could equally be a multi-user platform owned by one of the principal parties or by the FSP or the bank. Whichever platform solution is employed, this is where any automated electronic record compliance verification would take place. Article 11 states that any acknowledgement of receipt of an electronic record by a data processing system does not imply that an electronic record has been viewed, examined, or determined to be compliant or non-compliant by an addressee. It's just an acknowledgement of receipt. That brings this episode to a close. I hope that you found it interesting and informative. Please do leave a comment or email me directly if you have any queries or general feedback. Until next time, goodbye.